The impeachment court will now resolve the prosecution's request for the issuance of subpoena dated July 6, 2026, directed to the Commission or Internal Revenue. At the outset, the presiding officer reiterates and adopts by reference the court's citation of applicable rules regarding the issuance of subpoena ducis tecum, which forms an integral part of this order. The foregoing standards are deemed reproduced and shall govern the court's disposition of the present subpoena requests. After examining the records sought, the court finds that the requested documents meet the requirements set forth. They are reasonably described, readily identifiable, and prima facie relevant and material to the allegations under Article 2. However, the court, similarly, requests insofar as it seeks the records of JTC Group of Companies, Philippines Inc., and Pikimong Philippines Corporation. The prosecution failed to establish a prima facie nexus between these entities to either the respondent or to her spouse. The records sought, therefore, do not at this time satisfy the requirement of prima facie relevance under Rule 21 of the Rules of Civil Procedure. The court also resolves the respondent's objection to the requested period from 2007 to 2021. They anchored their opposition on the Supreme Court's pronouncement in Duterte v. HOR that the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. The argument, as stated earlier, fails because first, the documents requested under the subpoena ducis tecum will not be used to allege additional impeachable offenses. This court will not allow it. For the same reasons discussed in the court's earlier order, consistent with the same jurisprudence which are hereby adopted by reference, the court likewise holds that the requested records are sought to establish respondents' financial baseline and capacity only, not to inquire into or prosecute alleged impeachable acts occurring outside the present articles of impeachment. Accordingly, these records are required to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. We are also not without precedent. During the Corona impeachment trial, the Salens, prior to his appointment as Chief Justice in 2010, were presented on the January 18, 2012 hearing of the court. Likewise, evidence and testimony concerning properties and transactions before his appointment as Associate Justice were presented before the court on March 13, 2012. Therefore, the production of records from 2007 to 2021 is therefore allowed and authorized strictly for purposes of establishing a comparative baseline only. They shall not be used as proof of another independent impeachable offense. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term. The defense's invocation of the Race to the Privacy Act is likewise unavailing. As previously stated, Section 16B of that law expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of its implementing rules expressly permits the processing of sensitive personal information provided to government public authority pursuant to a constitutional or statutory mandate and when necessary for the protection of lawful rights and interests and court proceedings. The court is likewise unconvinced by respondents' argument that the issuance of the subpoena will usurp the authority of the BIR under Section 5 of the NIRC. This court is not determining the tax deficiencies or civil liabilities which remain within the province of the BIR. It is exercising its constitutional mandate to determine public accountability under the Articles of Impeachment. Neither does dependency of a BIR audit suspend or limit the Senate's exclusive jurisdiction to try impeachment cases. The respondent invokes Section 270 of the National Internal Revenue Code to prevent the production of the requested records. The objection is overruled in part. The Supreme Court expressly ruled in Dipad v. Spouses Olivan, GR 168771, that Section 270, quote, of the NIRC obviously does not address the confidentiality of ITRs. It merely penalizes the unauthorized disclosure of taxpayer information, except as otherwise provided for by law. It does not bar the production of the documents. However, the respondent correctly invokes Section 71 and other provisions of the NIRC, which recognizes only 3 instances in which a taxpayer's records may be opened for inspection. Number 1, upon order of the President or authorization of the President. Number 2, upon the request of a foreign tax authority with the approval of the President. Or number 3, upon the taxpayer's waiver. Nevertheless, the existence of these statutory limitations does not at this stage preclude the issuance of the requested subpoena. The issuance of subpoena is merely a preliminary procedural step and does not by itself authorize the disclosure, inspection, or admission of the requested tax records into evidence. In fact, this issuance is the order that shall set, if at all, things in motion. Upon service, the BIR Commissioner may refuse compliance, very much like what they did with the House, or comply by invoking any of the exceptions under the NIRC as previously mentioned, without a satisfactory showing of faithful compliance with any of the enumerated exceptions. This court shall not receive any subpoenaed records from the BIR, similar to what was done when the sealed box ordered by this court to be returned to them. There is also a precedent during the 2012 Corona impeachment trial. The Senate issued the subpoena and thereafter awaited the return of the BIR Commissioner. The requested records were produced only after the requisite presidential authorization had been obtained, one of the recognized exceptions under Section 71 of the NIRC. The respondent, however, is not without recourse nor remedy. In the event the requested tax records are lawfully produced pursuant to any of the statutory exceptions, the respondent may at the appropriate stage of the proceedings raise any and all objections concerning their relevance, materiality, authenticity, admissibility, and other evidentiary infirmities. The issuance of subpoena should not be construed as a ruling on the admissibility of the documents ultimately produced. On this basis, the subpoena shall therefore be issued, and we shall await the return of the BIR Commissioner, at which time the court shall take such action as may be deemed necessary and appropriate. Accordingly, in view of the foregoing, the request for the issuance of subpoena directed to Commissioner Carlito Martin R. Mendoza of the BIR is hereby granted. The request insofar as it seeks the records pertaining to JTC Group of Companies, Inc. and Pikimong Philippines Corporation is hereby denied for failure to satisfy the requirement of prima facie evidence. The Commissioner is directed to make the appropriate return to this court in accordance with the law on July 30, 2026 at 9 a.m. before the Clerk of Court. The court shall await the return before taking any further action as may be warranted. The parties are likewise directed to be represented by counsel on the aforementioned time and date for inspection, comparison, photocopying, and/or marking as the case may be. So ordered.